Welcome to this explainer. Let's just jump right in and set up the stakes for workplace retaliation. Honestly, this is a critical, highly complex issue that absolutely every employee, manager, and HR professional needs to understand if they want to survive and thrive in today's corporate landscape. We're going to unpack the legal framework of Title VII of the Civil Rights Act, and we'll specifically focus on exactly how the courts handle retaliation claims. Because it's really not just about knowing what's right and wrong, it's about understanding the precise legal mechanisms that trigger federal lawsuits and, frankly, massive financial penalties. Okay, so here's our roadmap for today. 1. Defining workplace retaliation. 2. The three legal elements. 3. The third-party twist. 4. Real reasons versus pretext. And 5. Creating an ethical culture.
Starting right off with Section 1, Defining Workplace Retaliation.
Just look at the sheer scale of this problem. We have seen a massive jump in EEOC retaliation charges. We're talking about a skyrocketing trend from just over 18,000 charges filed in 1997 to a staggering 42,018 by 2016. Retaliation has essentially become the single most frequently alleged basis of discrimination in the federal sector. Now, what does this tell us? Well, it shows that employees are speaking up more than ever before, but it also tells us that employers are consistently struggling to handle those complaints legally and appropriately.
So the crucial point here is defining exactly what retaliation actually means under Title VII. It's essentially a workplace reprisal designed to punish someone for speaking up. And the primary purpose of this retaliation provision is to ensure that our core anti-discrimination laws actually have teeth. Think about it logically for a second. If employees had absolutely no legal remedy against their boss for retaliating against them, they would never report discrimination. They'd just be way too terrified of losing their jobs. So the law steps in to protect them when they complain about status-based discrimination, things like race, color, religion, sex, or national origin.
Moving right along to Section 2, the three legal elements.
I want you to think of these 3 steps as your core rulebook. This rulebook governs whether a workplace grievance actually becomes a viable federal lawsuit. If you're the plaintiff, you've got to prove all 3 of these. First, you engaged in a protected activity. Second, the employer took an adverse employment action against you. And third, there is a clear causal connection between those 2 things. Let's break down exactly what each of these means in practice.
Now notice the big difference between the 2 types of that first element, protected activity. Participation is strictly legal and very narrow. It means you formally filed a claim, or maybe you testified in an EEOC hearing. The legal protection here is incredibly strong. Opposition, on the other hand, is much, much broader. This is the informal stuff, like complaining to your supervisor, sending a quick email to HR, or flat out refusing a discriminatory directive. But here's the catch. To be protected under the opposition clause, the employee must have a reasonable, good faith belief that the conduct they're complaining about is actually unlawful. You can't just oppose something completely trivial and expect federal protection to kick in.
It's super important to translate this into everyday workplace dynamics so we can avoid what we call the personal hostility trap. Just complaining that a boss has personal hostility toward you, or maybe they have general bullying tendencies, isn't legally protected opposition. Why? Because, being a jerk isn't federally illegal unless it is specifically tied to status-based discrimination. If you fire off an angry email to HR saying your boss is out to get you, but you totally fail to mention that it's because of your race, your gender, or your religion, the courts will probably just throw the retaliation claim out. The employer has to be put on notice that you are opposing civil rights violations, not just bad management. Okay, moving to the second element, an adverse action. The Supreme Court established a pretty broad standard for this. They say it's any action that might dissuade a reasonable worker from making or supporting a charge of discrimination. It's not just getting fired. It could be a demotion, an abusive workload, or even things that happen outside the workplace, like spreading false rumors. And context matters immensely here. For example, the courts have pointed out that a schedule change might be a minor, trivial annoyance to an unmarried worker, but heavily punitive and completely disruptive to a working mother with school-aged children. The standard is simply whether the action would terrify a reasonable person into staying silent.
For the third element, causal connection, things get a whole lot tougher for the employee. Based on recent Supreme Court decisions, plaintiffs must prove strict but-for causation. What does that mean in plain English? It means the employee has to prove that the firing, demotion, or whatever adverse action simply would not have happened but for the employer's motive for revenge. It's really not enough to say retaliation was just one of the reasons you were fired. You literally have to prove it was the ultimate deciding factor. That is a very high bar to clear and a really powerful defense shield from employers.
Let's dive into Section 3, the third-party twist. So check out this really surprising case. We've got a man named Eric Thompson and his fiancée Miriam, and they both worked at a company called North American Stainless. Miriam filed a gender discrimination charge with the EEOC against the company. Now, about 3 weeks later, the company didn't fire Miriam. Instead, they fired her fiancé, Eric. Naturally, Eric sued for retaliation, but the company argued that Eric couldn't sue because he wasn't the one who engaged in the protected activity. Miriam was.
Well, this case went all the way up to the Supreme Court, and the late Justice Antonin Scalia, writing for a unanimous court, completely rejected the company's argument. He ruled that punishing a close family member is almost always an adverse action that would terrify someone into silence. Crucially, he noted that Eric wasn't just some accidental victim. He fell well within the zone of interest protected by the law. This was an absolutely massive expansion of the retaliation doctrine, meaning employers can absolutely be held liable for striking at the family members or close associates of a whistleblower.
On to Section 4, Real Reasons versus Pretext.
Now, in these lawsuits, you'll see a constant shifting of the burden of proof. Once an employee establishes their initial case, the employer gets the chance to say, wait a minute, we didn't fire them for complaining, we fired them for a perfectly legitimate job-related reason. This could be poor performance, insubordination, or maybe repeated safety violations. At that point, the burden shifts right back to the employee. The employee now has to act like a detective to prove that the employer's excuse is actually a pretext, a fake, fabricated reason designed purely to hide a retaliatory motive.
Courts are basically looking for the glaring tracks of a cover-up. If an employer claims someone was fired for poor performance, but there is a total lack of documentation, and all their past performance reviews were absolutely stellar, well, that's a huge red flag. Another massive indicator is inconsistent treatment. Say the complaining employee is suddenly fired for being 5 minutes late, but 3 other coworkers who never complained are routinely late with 0 consequences, the court is going to see right through that. And of course, suspect timing, like getting fired mere days after filing a harassment complaint, is very often the strongest circumstantial evidence an employee can wield.
Let's look at a real-world example of this totally unraveling. Take the case of Tang v. Citizens Bank. An employee complained that her supervisor was sexually harassing her. Shortly after, she was terminated, purportedly for failing to submit a project before going on vacation and for making a material mistake. Sounds like a legitimate reason, right? But the employee proved it was a pretext because she produced an email from that very same supervisor actually thanking her for completing the project while she was on vacation. Furthermore, the employer couldn't even explain what the supposed material mistake was. The fake excuse completely fell apart in court.
And finally, Section 5, Creating an Ethical Culture.
You know, the ultimate secret to avoiding this whole retaliation trap isn't just about having a team of good lawyers. It's really about establishing a corporate culture of total integrity and inclusion. This has to be anchored by a clear, continuously communicated code of ethics. You absolutely need anonymous reporting channels so people actually feel safe. But most importantly, you need rigorous training. Managers must be trained not to act on their initial feelings of revenge or anger when someone complains about them. Look, it's human nature to feel defensive, but it's a massive federal liability to act on it. A strict, zero-tolerance policy against whistleblowing reprisals empowers everyone to speak up without fear.
I'm going to leave you with this final thought to chew on regarding the shared values and daily realities of your own organization. Take a hard look at your internal environment. When someone raises a concern, are they celebrated for protecting the company's integrity, or are they kind of subtly marginalized, excluded from meetings, and eventually pushed out? Understanding the legal mechanics of retaliation is vital, sure, but embedding that understanding into your daily operations is what truly matters. Because at the end of the day, a culture that fiercely protects its employees ultimately protects itself.